welcome to another edition of Wealthy and Wise. I'm your host, Adam Kintigh, and I am here with the wonderful David Vanlandingham at the Real Estate Wealth Builders Conference in St. Louis. We're at the beautiful Railroad Pass Hotel. Union Station Hotel. It's a fun time. Lots of action going on here.
Absolutely.
So I figured while we're here, not a better time for us to talk about how to structure real estate. And we have seen so many different strategies of people having one LLC for every property. Do I set up a Wyoming company to own another LLC that then holds title to the property? And we have seen it all. I think I've talked to about 30 people today that all have a different approach on how to hold title to real estates. And David, one of the things that you are always reminding is that the structure needs to be manageable, scalable, and financially efficient. So give me a little rundown of, in your view, the best way for us to structure residential rental properties as folks are building out their rental portfolio.
Yeah, absolutely. Thanks, Adam. You're right. A lot of people have the different opinions on how to do it. They talk to different attorneys or other people that are doing the same thing. Doesn't mean it's the right way. Doesn't mean it's the best way. So when we look at this and we look at a client's portfolio, if you will, wherever they're at, whether they're brand new or they're just getting in or they've been doing this for a while, we want to know what they're looking to accomplish. What are their goals? So when we talk about long-term rentals, you're right. A lot of people talk about, well, you're just going to get an LLC for every property. I can tell you that is very cumbersome because if you have 20 properties, now you have 20 LLCs, you have 20 renewal fees, 20 record book walkthroughs, 20 checking accounts, and you got insurance. So it's very draining financially, and the ongoing maintenance cost is even higher. So what we look at is how can we do this financially efficient? And that's really the key. But we also want to, from an asset protection standpoint, make sure that these properties are separated. And that's why a lot of people think, well, just one for every one. Because we know if we take an LLC and we put 3 or 4 properties in there, if a legal action happens and affects one property, well, it could affect the entire load of that LLC. So what we want to do is still be able to segment, but at the same time, we need to avoid the due on sale. So if there are properties that have mortgages on there, if you just stick that into an LLC, the chances are sooner or later, your mortgage company is going to send you a letter and say, hey, Adam, not cool.
Now, hang on for 1 second. So I've heard that banks really don't care. After you close on the property, you put it into an LLC, and most likely they're not going to invoke the due on sale clause. Have you ever had a bank actually, or any of your clients where a bank has invoked the due on sale clause?
Absolutely, many times. I won't mention the bank, but it's a pretty popular one. And what happens is, so banks sell mortgages, right? So here's what happens. This is the way they typically find out there's been an unauthorized change of title. And that usually is triggered by either an internal audit or if the bank sells the mortgage to another company. They're going to see that. And they're going to send you a letter and say, hey, Adam, not cool. We vetted you for the loan. We checked on your credit. We checked on your employment. We checked your DNA and everything. We gave the loan to you. We don't know who this LLC is. So those are things that could check. If you're ever behind on payments, now they start scrutinizing to see what you're doing, right? They don't know who the LLC is. So we take advantage of a law that was created in 1982, typically called the Garn Saint Germain Act. And what that act does is allow us to take an encumbered property, place it into a qualified inter vivos trust, which is a form of a living trust, but dealing specifically with real estate. And as long as it's 4 doors and down, so quad, triplex, duplex, single family, we can do this on any federally backed mortgage. They cannot do the due on sale. But it also gets your name off of title because now we're going to retitle that property in the trust, typically after the street that the property is listed on.
The 123 Main Street Trust.
Absolutely.
The 707 Oak Street Trust.
Yep. Now, all by themselves, those trusts don't provide any asset protection. So now we start connecting the dots. So we take the lifetime beneficial interest of that trust and assign it to a disregarded LLC.
Now, when you say disregarded for tax purpose,
right?
Meaning it will not have to file a separate tax return.
Exactly.
Profits and LLC collects the rent, pays the expenses, whatever's left over, write yourself a check.
Yep.
Tax time rolls around, you are not expected to file a separate return. Any profit or loss will report on your 1040 Schedule E, exactly the same as if you did not have the LLC, but you get the protection.
Exactly. So you're not changing from an accounting standpoint. Does it become a nightmare, right? So then we look at the death time beneficial interest, and we assign that to a revocable living trust.
The family trust.
The family trust, the dynasty trust, if you will. And the reason we do that is because we want to avoid probate, right? So upon death, the membership certificates of the LLC are held by the revocable living trust. The death time beneficial interest of that real estate privacy trust is held by the revocable living trust. So we're going to bypass probate, yet we still get the step up in cost basis, which is, that's the wealth builder, the generational wealth builder that these trusts provide. So you buy a property for $200,000, it's worth $1 million the day that you die. It passes to your 19 kids that you have, Adam.
Mm-hmm.
If they sell it for $1 million, they pay no capital gains on that. Now, if they hold it for a couple years, now it's worth 1.2 and they sell it for 1.2, then yes, they'll be taxed on the 200,000 gain. But it's an amazing tool. It's actually been around since the Civil War. Originally, these trusts were called an Illinois land trust because that's where they first started. Back in the Civil War, this is the type of trust that surreptitiously they used to grab land for the railroads. So if I walked up and knocked on the door and said, hey, I'm from B&O Railroad, I'm here to buy your land, prices just went up. But if it's done through these trusts, nobody knows. Walt Disney did the same thing in Florida to acquire all of that land for Magic Kingdom.
So the land trusts are a great way to hold title to the property, separate the liability. So if I have one LLC and under that LLC I have 4 rental properties, how are those trusts going to separate the liability? If there's a problem with one, can it affect the others?
Possibly. Well, an attorney can come after anything they want. We know that. But what role did those other properties play in the accident, right? Nothing virtually. So they are in self-contained trusts, little bubbles, and we can reassign the beneficial interest from that LLC to another LLC. They may wave the flag of fraudulent conveyance, but again, if those other properties were not involved, had nothing to do with the business accident, if you will, it's going to be very hard pressed to move forward with that.
Beautiful. So this is where it becomes financially efficient. What are the ongoing cost of having a land trust?
0. So it's a one-time fee you pay for it. Now, if you do take it out to refinance it, put it back in, it's just a quick claim deed, minor cost. But yeah, that's why it's so financially efficient. You only have a renewal on that LLC. All the other trusts, including the revocable trust, no annual fee, no state fee or anything to that.
So as I learned about this, one of the things that I was excited about is so many people are told that they should have one LLC for every property to separate the liability. Now we've got renewal fees and checking accounts, and it really turns into a nightmare to manage. So in this situation, that one LLC on public record owns nothing. There's no evidence that shows that that LLC owns 3 other properties.
Correct.
On public record, the LLC is an empty shell, money in, money out. So it makes it, most lawyers, before they take a case, they're going to do an asset search and let's figure out what do these guys have that we can go after.
Exactly.
And in this case, they're going to do an asset search and they're going to find one property in one trust and nothing else.
Right.
So that really stems off those frivolous lawsuits, the professional tenants that move in, because today's world we live in, they're not coming to look at your property. Right. They're not coming to rent your property or buy your property. They're coming to slip and fall and file a lawsuit. So this is, in my view, is a great way to do it. Now, I want to shift gears and talk about, so the land trusts are going to hold title to the property. We hear all kinds of things about incorporating in Delaware, Nevada, Wyoming, or just in your home state. And what is your opinion when it comes to where to form the LLC? What is really the best?
Well, Delaware's been in the news lately, haven't they?
They sure have.
So I think that cost Elon $55 billion. And I think people are getting a little bit leery. So more people are opening up their minds to Nevada and to Wyoming. So we look at Wyoming and we look at Nevada simply because of the laws that were built around, formations of corporations in Nevada particularly. It's something I guess we're not proud of, but we're proud of. It was, the mafia is really probably why. When the mafia rolled into, Bugsy Siegel and Meyer Lansky rolled into Las Vegas, I'm sure they had every lawmaker in their pocket looking for the best protection. So the corporate laws of Nevada have always been great. LLCs have not been around forever in the United States. They only started in 1977.
In Wyoming, right?
In Wyoming, yeah, exactly. So Wyoming had their laws, and what Nevada did very smartly is they started applying their corporate laws to those LLC laws. And for many, many years, everybody was incorporating in Nevada for that very same reason. But the the cost of that ongoing fees and maintenance and business license and things like that was creeping up year after year, where Wyoming has always been on the cheaper side as far as incorporating. And when you have annual fees on an LLC that's holding 4 or 5 real estate privacy trusts, your annual cost is typically less than about $300. So it's not bad at all.
Now, I just literally not 10 minutes ago talked with a gentleman that has 3 rental properties, each in their own Minnesota LLC. He is an agent and living in Wisconsin. And in his situation, he had 1 LLC for each property, and he had an LLC for his real estate agent income. So understanding we're trying to keep your active income and passive income in separate entities. I know it causes all kinds of tax problems when you're
Correct.
flipping houses or active income or even holding rentals in an S corp or an LLC taxed as an S corp can be huge tax problems. But in this situation, I reminded this gentleman that he has children, and they're going to start driving soon. And if they get in a wreck, guess who's getting sued?
Him.
He will get sued.
Yep.
Lawyer, first thing he'll do is look on that ticket where his son got in a car accident, pull up his address, and let's see what this guy has. And within a matter of 5 minutes, he will know everything this guy owns.
Welcome to the world of the internet.
Which is crazy to think about. But if he gets sued personally, he gets drug into a lawsuit. In a deposition, he's got to list everything he owns: his house, his cars, and he owns the Wisconsin LLC and the 3 Minnesota LLCs. Talk to us about the special protections that we get in Nevada and Wyoming. If he would have set this up in Nevada or Wyoming, what would have happened?
Well, let's first address the Minnesota and the Wisconsin, because here's the thing. They don't have reverse pierce protection. We often talk about piercing the corporate veil. We know that's where they're looking to remove that shield of liability and come after you personally. In a lawsuit that starts at the personal level, they can actually reverse pierce up into the holdings of those Minnesota and Wisconsin LLCs. So now they can go after those assets. So it's kind of like a reverse on charge and order protection. So with Wyoming and Nevada, there is that reverse piercing protection. So if you do something as an individual, you don't have to worry about them being able to cross in and get into your LLC. So the big thing here is with Wyoming and Nevada, we do what's called top up and bottom down protection. So you're protected from your business, but more than likely your business is protected from you. I can tell you, my 60 years of living, I've done a lot of dumb things as an individual, pretty smart as a business owner, but could there have been something you did as an individual that could have affected your business? So we always have to consider both sides of that.
So the setting it up either in Nevada or Wyoming, you get the reverse piercing protection. They can sue you, they can win. They cannot touch your Nevada or Wyoming entity.
Correct.
To satisfy your personal debts and obligations.
Correct.
Which is something that people need to know, because you look at the parable in the Bible about building your house on sand. We know that it is going to fall.
Correct.
So the smart man, the wise man, built his house on a rock.
Right.
And in my view, as people are starting to get into investing, oftentimes, and I asked that same gentleman, so who formed this LLC for you? And his response, of course, was, well, I formed it myself.
Right.
Spent a couple $100, formed the company, and I'm good to go. Talk to us about what would happen in the event of a lawsuit. So this guy's got his 4 LLCs, lawsuit happens.
Right.
What is the first thing the attorney is going to do?
Well, they're going to go after anything and everything they can. That attorney represents their client, so they're going to try to get as much for them as they can. And that's them doing their job. That's not being a bad attorney. They're actually being a good attorney. They're trying to, for the best of their client. And a lot of people will throw in, well, what about insurance, right? I've got umbrella insurance. First of all, how many people have actually read their insurance policy to find out what's included and what's not included? The insurance company's first responsibility is to themselves and their shareholders. So there's many incidents or accidents that can take place in that LLC that may not be covered by that policy. So once again, they're putting themselves right back in the line of fire. And to a client that has those multiple LLCs in different states, guess what? Not going to get into the Corporate Transparency Act today, but now he has to file a beneficial ownership information report on every single one of those LLCs.
That's true.
So it can be cumbersome just by doing that as well.
Good. So we're closing up here, David. We've got a lot of people here that are waiting to speak with us, but We appreciate your time. We appreciate you taking time out of your day to be here with us today.
Absolutely.
Thank you all so much for tuning in to Wealthy and Wise. Have a fantastic rest of your day.
Take care.